right to it, but I don't know if he has a right to stand here and be distracted. I think he could sit like everyone else.
I think you have your picture.
Well, I'm taking some video. My intent is not to distract, I assure you.
Video now.
I make the motion to go to executive session, see Vice Deputy Attorney General.
Second. All those in favor?
His second. So the recording of this hearing is permissible?
Yes.
You don't record though, do you?
The press?
No.
We don't. We don't know now. The press is, reporting.
Okay. So, so the two-part analysis in regard to my case, pre-2008, post-2008. As to pre-2008, the division, to my knowledge, the only thing that they have set forth is that I was an independent contractor and that I worked under a professional services agreement. I don't think that that accurately reflects the actual relationship, but more importantly, I believe that that analysis is contrary to the law and it's contrary to the clear custom that was going on prior to pre-2008. And I started discussing the Fasolo case, and with the Fasolo case that was issued by the Appellate Division in 1981, what that case stood for is that Mr. Fasolo, the plaintiff, was a part-time township attorney. He had his own law practice. He was paid by the two townships that he worked for with a salary as well as for additional work for typically for litigation. He would be paid on voucher. And that's what's called, I think commonly called a hybrid form of being paid. And thereafter, in the course of his employment, he had a special contract with one of the towns to do work for a new sewer line. And for the sewer, and that was referred to in the case as the sewer attorney services. And as to that provision, the town agreed to pay him a flat fee. They paid it in increments over 4 years, and he would be paid additional fees under voucher for litigation or condemnation actions. And the Attorney General's office, at this stage in the proceeding, the Attorney General's office provided an opinion to this board. And the opinion is referenced in Fasolo, and what the opinion states, the Attorney General's opinion states, is the following. In conclusion, you, meaning the PERS board, you are advised that for purposes of pension credit, services performed as a part-time municipal attorney for local government subdivisions, compensated for by a fixed annual retainer, are to the extent regarded to be eligible for services coverage by the Act, where the retainer or salary can be demonstrated to be paid under regular salary policies, that's element number 1, regular salary policies of the government entity, and it's incident to services performed in a government office or employment. It goes further on to say that the credible service and compensation of Fasolo for eligible retirement credit should be limited to his services and compensation as the magistrate, he was also a judge, as the magistrate for the Borough of Tenafly, and for his professional services compensated by the fixed annual retainer. And that he does not qualify for any compensation under voucher, nor did the Attorney General say he should be compensated for the special assignment as sewer attorney. The board then heard the case. Fasolo wanted to be compensated for everything. And the board heard the case and agreed with the Attorney General's opinion and ruled you're eligible for the component of your salary, you're non-eligible for any voucher services, and for that special assignment as sewer attorney, you are ineligible. The Appellate Division, then ultimately the case went to the Appellate Division because Fasolo was insisting that he should be eligible for all services paid. And the Appellate Division found, they said, they make a reference saying it is of no trouble for us to find that as to the salary component, he's eligible for PERS. It's also, and they said, and clearly for the voucher, that's excluded. But the Appellate Division made a more liberal decision of compensation regarding the issue of compensation by finding that his retainer, the fixed fee for the sewer attorney, even though it was a special assignment, that was eligible for compensation. Now, in my case, my situation was I was always on salary, and I was also had professional. I was also able to voucher for litigation, but I was like the solo that where the Attorney General's office found it was eligible for PERS, where this board found it was eligible for PERS, and the appellate division stated it had no trouble finding it was eligible for PERS.
Are you pre or post 2008 now with,
Pre.
with your statements?
Pre.
So you're
This
still
is all
pre.
pre,
Okay.
yes. Yeah, I believe that going retroactive is really troubling to me. So, so that was the law, and what has explained to me by the chief financial officer of the city of New Brunswick is that the standard was if it was salary paid, by general salary, provisions, and if you made more than $1,500, you were in PERS whether you wanted to be or not. And so that it wasn't that uncommon that people did not want to contribute to the pension, and yet they had to. So that was the general practice up to the point of 2008. And then in 2008, then they passed the statute that calls into question. And in the statute, it's very clear that they're saying professionals pursuant to a professional services agreement are not eligible, are no longer eligible for PERS. And it goes on in section B to say persons who are employed that would meet the definition of an independent contractor are no longer eligible for PERS. But as to both categories, this is what I think is very interesting, that as to both categories, both professional services agreement and independent contractor, the legislature said that nothing contained in these subsections shall be construed as affecting the provisions of any agreement or contract of employment in effect on the effective date of this act, and that there can be no renewal or extension. And what I would suggest from the language that's in there is that the statute is very clear. And what they were saying is, we know that in the past, people were being deemed PERS eligible, that we are saying they should no longer be deemed PERS eligible. Those are professionals pursuant to a professional service agreement, or even those who would meet the definition of independent contractor. And they said, but the fact that you cannot extend that from 2008 going forward, but it's not going to interfere with any existing relationship, that they're saying we are not going to make this retroactive. That instead we understand, we're trying to improve the financial stability of PERS, but at the same time, we understand that we have made a promise to a lot of people. And that promise was that there would be a pension in your future. So we're going to abide, so now that we're changing the law, we're still going to abide by that promise that we made up to 2008, and now we're changing the law.
So your argument is that prior to Chapter 92, even if you were an independent contractor, you were eligible to be in PERS. That's what Chapter 92 changed the concept of independent contractor. Is that your argument?
It's a little bit more subtle than that. Because in the context, because the statute finds that even if you meet the definition of independent contractor, we're not going to interfere with it. But so there would be circumstances where you would be an independent contractor, and if you were, I would suggest if you had issues of fraud or illegal behavior, then that would disqualify you. But they specifically said if you were in PERS prior, and even if you would meet the definition of independent contractor for those years, we made the promise and we're going to honor it.
Can you tell me where it says that?
Yes.
Those words.
Yeah, nothing contained in this, I'm reading that from the statute. Nothing contained in this subsection shall be construed as affecting the provisions of any agreement or contract of employment in effect on the effective date of Public Law 2007, which is this act. Whether or not the agreement or contract specifically provides by its terms for membership in the retirement system. No renewal, extension, modification, or other agreement or action to continue any such agreement beyond its current term. So they're saying that if you were an independent contractor, if you had an employment relationship with a government entity, and it could be construed as an independent contractor, you cannot renew it, extend it, or modify it, but nothing beyond, beyond its current term, and shall have the effect of continuing the membership of the person in the retirement system. It could only mean that.
Are you aware of any case law preceding chapter 92 dealing with eligibility to remain in PERS as an independent contractor?
Preceding,
Chapter 92.
subsequent to 2008, or before
No,
2008?
prior.
Prior to 2008?
Yes.
Well, clearly, Mr. Fasolo could have been construed as an independent contractor.
No,
Clearly.
I'm asking you if you know of any other cases.
In fact, he was. That's why they outlawed his receiving fees as a person.
I mean, so, and I know of no case, well, I was unable to find any case that runs contrary to this law. And where the basis was, so long as you were receiving a salary, performing services commensurate with that salary, that you were entitled to PERS. I mean, there must be thousands of people.
Well, the concept of an independent contractor versus an employee and eligibility to be in PERS was not something that just happened as a result of chapter 92. And there is case law prior to chapter 92 that does not permit an independent contractor to remain a member of the public employees retirement system. So I'm just having a difficult time with your argument that even if you were an independent contractor,
Well, I would,
this changed it and said, we won't touch on that.
well, I may not be able to change your mind with what I have to say, but I'm gonna try. Because
I
would-
appreciate your argument, I'm just
because
trying, I was hoping you would say yes, so you could explain to me how that fits into your argument.
Because it would make no sense then, if what you're saying, that if you were an independent contractor back then, and should found that if you contributed to PERS from, let's say in my case, from 1987 or 1992 to the present time, during those years, we subsequently look 20 years later and find that you're an independent contractor, so we're gonna disqualify my situation. It would make no sense for the legislature to specifically include within the statute the status of independent contractor, and then say that this will not affect any prior agreement. There would be no purpose for that.
If I might. 2 points. You recognize the fact that however you are paid, whether it be a W-2 or a 1099, does not in and of itself make you or not an independent contractor.
In and of itself, no, but it's an indication of
I don't
status.
disagree with you. You're also aware that there are arrangements made by townships, municipalities, other agencies that are primarily to satisfy the requests of that professional, that some professionals were in there. This would be covered for health insurance and paid for their benefits through those particular arrangements, and that we're not and should not have been in PERS in any way, shape, or form, because we're actually a independent contractor, and that the terms of the professional services agreement were really what was the determining factor in, as one of the major factors in the determining of what is an independent contractor and what is not.
Lost it, I'm sorry.
Okay. There is a 20-point some odd test that the service uses
Yeah.
to determine who is and who is not an independent contractor. It exists outside the public arena. It was not intended for the public arena. It was actually intended to determine who should withhold taxes on an individual.
Okay.
The intent of the test in the law was to force employers that had independent contractors to withhold payroll taxes on individuals that were technically and there before thought to be independent contractors. That
You
they
mean
had
the
to pay
law
their own
created
taxes.
the 20-point factor?
That's correct,
Yeah.
and that's where it came from.
Okay.
It wasn't intended to say that you were a particular employee. It was determined just to collect taxes. So that was the purpose of the statute and the reg. Now it has been used by public agencies to determine that, but it's the other side. It's the other side to prove that you are an independent contractor,
once-
not an employee.
Once again, I feel as though there is a resistance to just reading the literal language of this statute. And
That
interpret-
statute
and
was not,
interpret-
listen, I've been on the board 21 years, okay? So the point here is that we have determined many, many times before you arrived, and before the arrival of Chapter 92, that independent contractors could not be in the benefit system. period.
Well,
I think
and that- and-
Stevens was the name of the case that said you
Stevens?
use the factor test to determine independent contractor status.
So, I mean, that's the issue. It's not, the paragraph from section 92 is not the determinant factor for your service prior to 2007. So, I mean, I
Well,
understand
if-
your reading of the law, but
Well,
I'm trying to get the nexus between what you're saying and what you did prior to.
What does the legislature then possibly mean then when someone could be classified as an independent contractor? And what could the legislature then possibly mean when it says that nothing contained shall be construed as affecting the provisions of any agreement or contract of employment in effect on the effective date? When it's referring to specifically the paragraph dealing with independent contractor? What could they possibly have else meant?
How does that alter the law that says an independent contractor in any way, shape, or form should not pay benefits?
Because the state legislature is creating a law saying that. And I would say in addition to, in addition to that, when you're saying that the 20-point factor test really doesn't apply.
No, I didn't say it didn't apply. I said it's the inverse of what the intent of the law that was passed originally in the private sector, not the public sector.
But the state legislature once again adopted it because they
At
they
the
said-
inverse, not to the negative, not to the positive.
What, okay. It's saying, what I wanted to talk about a little bit later is that the statute says that the independent contractor status is to be evaluated by the regulation or policy of the Federal Internal Revenue Service.
Which I've
For
had
the purpose
for
of the
4
Internal
years, and I
Revenue
can tell
Code.
you right now that is the inverse of what you're trying to prove.
All right, so what we're trying to do is just understand your logic. We get your reference points, we get the statute that you're quoting now a couple of times. We're just trying to understand where you're coming from and your logic based on the documentation we have in front of us. I think we're good to move on.
Yep.
So that covers your pre-2008 logic, or is something
Well,
still add to the
I would suggest, I
post
mean,
as well?
I would say that along with the statute, along with that, this was, to my knowledge, the common practice, and it seems as though there have been other matters that have come before this board where, for various reasons, attorneys had pre-2008 status, similar to what they had post-2008, and this board only took action, or I should say the division only sought action up to 2008. In my opinion, they honored the spirit and clear intent of this statute. And and to me, I'm really struggling with how my case is distinguishable from any of those other cases that this board heard and ruled on. These were professionals, these were attorneys performing professional services just as I was, and presumably were at some form of salary.
We're not gonna be able to get into your logic here, because we can't bring up every other case we've heard pre-2008 to deal with contractor versus employee. So duly noted, we understand your logic, we understand your point of view here.
And of course, that may be for another time, but I think the board should have a serious concern about consistency of its decision-making as to, so that the public can have predictability as to how this is going to handle, and how some attorneys, the board decides, well, the division only went to 2008, so we're just going to affirm that, even though they had prior years.
They're fact specific. Each case has its own fact base. Your fact base is different from theirs. And
I've spoken to a number of them, and
reflect
it seemed like the basic, simple facts are they performed government services prior to 2008 under salary and subsequent.
I can appreciate your position, but you testifying to what their facts are to us is, again, I think with the chairman is suggesting the facts and circumstances of each case are considered on that basis. So.
Well,
Are there any other questions?
I would say that I would say that in regard to post 2008, once again the division just went to that they just said that I signed an employment contract, and they said basically that the employment contract was tantamount to a professional services agreement, so I'm disqualified. But I think in going with, I believe that the title itself of the document should not define the relationship. You should have, you should look into substantively what the relationship is all about. And in looking at the factors, I would suggest that there are, in any time where you have part-time employment, there are factors that could support independent contractor and factors that could support employment. And my situation is no different from that, so you could easily find there are going to be some factors that says it's an independent contractor, but I would suggest that there's strong factors that suggest employment. The most importantly being the long-term relationship that I've had with the city, 28 consecutive years, that I was always paid a salary, that in 2008, then I changed the nature of my relationship where there was no longer a hybrid, it was just a pure salary regardless of the amount of work that I performed, regardless of the amount of litigation that was involved, that I was always have been providing support staff by the city of New Brunswick in performing my services and provided with benefits, and so that there was, and I think what weighs heavily is what was the intent of the employer. But yet they reimbursed me for all my costs, including photocopy charges and mileage on my car, which would be consistent with employment. And they reimbursed me for seminars that I've attended. But I would never think in those situations that I was an employee of these particular clients. But my situation with the city of Brunswick was definitely different. Because in addition to those rather strong factors, there was other factors where I, in my years past, attended a seminar in my efforts to become what was called a certified municipal diplomat, and the city reimbursed me for those seminar costs. I have a parking pass at the city parking lot. I have an email address with the city of New Brunswick. I've attended required seminars by the city on sexual harassment and active gun shooters, active shooters. They provide me with a law library. None of my clients outside of the city of New Brunswick provide me with these type of services that I would suggest are consistent with employment. And so when this whole issue came up, I think the city did the right thing, and that is they forwarded to the IRS and sought an opinion from the IRS. And I know that this board and the division is independent of the IRS, but nevertheless, the statute says that you should, in evaluating independent contractor, that it's to be guided by the regulations and policies of the Federal Internal Revenue Service. And the Internal Revenue Service made it completely, and they are completely independent, have no agenda on this matter.
Yes, they do. I'm sorry.
Well, not to my perception.
Well,
Not to my perception.
I've been with the IRS for 40 years, I can tell you, yes, they do. Their entire Internal Revenue Service is entirely based on the fact that it wants to collect revenue. That is its mission. The appropriate and fair implementation of a tax system, not to determine your employment status.
Well, I have faith in all our government institutions, and I believe that the
I'm glad you do,
IRS.
but that's not the issue here. The issue is not whether the Internal Revenue Service wants to rule on your employment status. It's this board, and I'm telling you again, the employment status as to the Internal Revenue Service is for the collection and withholding of taxes. That's its purpose.
Well, certainly the purpose of the courts have said that whenever in doubt, there should be a strong social policy to find employment. And so.
You're well over your 5 minutes. Well,
I know, but this is an important. This is
we
important.
can wrap it up. I'd appreciate it.
Okay. So I would say that by the IRS evaluation, I think you should give great weight to that. And I would say in evaluating how the division, in determining all the facts and circumstances of this, I believe that there are many inconsistencies in the division's position in this matter, and how the division has handled this matter, quite frankly. For instance, the division has said that for the years 1987 to 1992, when I was the municipal prosecutor, they're not challenging those years. But yet, from the time that I was the municipal prosecutor for the year of 2000, did the same work, same employer, same situations, that's challenging. I'm scratching my head as to what's the logic behind that. As to they seem to be creating their own rulemaking, and even though they're under a statutory mandate to follow the Internal Revenue Service rules and policies, and they seem to suggest that it's quite acceptable to have rulings that are inconsistent with the IRS. And I would suggest this board that's not in the best interest of the state of New Jersey to have inconsistent rulings where people don't know what's the standard as to what's going on. The whole process, I included in there the various letters that I wrote to the division seeking information, just trying to find out taking away a vested right with me, something as sacred as a pension, is something I clearly relied on. Over 28 years, I made very conscious decisions throughout those 20 years, which I identified in my memo as to relying upon the fact that I would have a pension in my future. They have been secretive about this. And to me, I think that runs contrary to a basic fundamental premise of government in the United States, of openness and transparency. And to have this labeled under fraud and abuse, quite frankly, is offensive to me. I mean, I have worked hard to do a good service for the city of New Brunswick. I have worked hard over 28 years of having my law practice in the city of New Brunswick to develop a good reputation, and then to have this reported out in the public, in newspapers, on websites, of being investigated by fraud and abuse is really inappropriate. And I don't know why that section is titled that way, and I don't know why that section was entrusted to handle this responsibility, because one thing is for sure, there was never fraud or abuse. In this matter, this was always out in the open, and I always handled myself honorably, and I know the city of New Brunswick has done so. Reasonable minds can differ on this topic, but that does not rise to the level of fraud and abuse. So I think you should question seriously the inconsistencies on the division's part in determining what, as to whether I should be deemed to have eligible years of service in hers.
Mr. Bucca, the fraud and abuse unit, I believe, takes its title on this mission from an executive order. It's not from the board. You and I have spoken privately about it.
Well, they should be more careful because labels are grounds to be manipulated.
I guess my point is, it's not something that's within.
Not by this board or anything like that, but by other people.
But it's not our call.
That's something we have no control over. But the
They
question,
should make a
the question I would
recommendation
like
to
to
change their name.
May I ask a factual question?
Well, add that to the list of requests.
I'd like to ask you this one. Could you address, Mr. Bucca, as I understand in your current agreement to post-2008, you're required to provide your own secretarial services at your own expense and your own substitution of attorney at your own expense. Could you address that?
I could, and all I could tell you is that that's what the agreement said, but that's not what the practice was.
What was the practice?
The practice was, number one, I never had cause to have someone else do the work for me. I had one situation where there was an allegation of conflict of interest, and another attorney, the Board of Adjustment attorney, at no cost to me, at no cost to the city of New Brunswick, handled that application. In all the other applications, I did all the work, so there was never cause for a substitute. For all the support staff, the overwhelming part of the support work, with one exception, typing of resolutions, my secretary at my private office typed the resolution, but anything else was handled by the support staff of the Department of Economic Planning, Policy Development.
And I think your submissions also say that previous to 2008, that was generally the case, but there were some exceptions where members of your firm did some of the work?
That was pretty much always the case.
And
You mean as far as my doing work or someone else? The only time, sickness or a vacation, but I'm very confident saying, if you looked at all my records, hearings I was supposed to be at, I am sure I was at 95 to 98% of those hearings. It was just every once in a while where we all have issues where we run into a conflict. And I never had, I don't ever recall ever having to pay anyone.
thank you.
Kristen Bell with the Pension Fraud and Abuse Unit. When we first looked at Mr. Bucca's case, we saw that it went from a PSA over to an employment contract, and we wanted more information. So we requested all of the documentation the town had available. When we looked back at that documentation, we saw a relationship that didn't speak of an employee-employer relationship or a genuine hybrid situation. So we originally violated Mr. Bucca all the way back. When we were preparing the packet for the board, we looked again and we said, municipal prosecutor time, we don't have substantial documentation, we don't see a situation that shows a retainer and salary for the same services. When we looked at the time past that, we saw that relationship starting to appear, especially with, it's your board packet, page 65. In subsection 2, they discuss the way in which Mr. Bucca would be compensated. So that is why we looked further back prior to '08, because we saw a relationship that never really seemed to bespeak of an employer-employee relationship, but rather an independent contractor who is getting a retainer and salary above hours of service.